NACDL is the association of the nation's criminal defense bar.
Good afternoon, everyone. Thank you again for joining us for today's webinar, which is entitled Unlocking the Jury Box, How Felony Disenfranchisement Contributes to America's Jury Diversity Problem. My name is Monica Reed. I have the pleasure of serving as the Director of Advocacy here at the National Association of Criminal Defense Lawyers. And April is Second Chance Month, which I'm sure a lot of you have attended programming to that effect. NACDL kicked off its Second Chance Month programming with a virtual discussion on second chance stories, which highlighted our Return to Freedom project and the individuals who were released from long periods of incarceration and their pro bono attorneys who were paired through the project. We followed up with a second program on last week in partnership with the Sentencing Project that talked about second look sentencing reform, really discussing our country's continued over-reliance on incarceration and extreme sentences, and really the harm that they continue to cause. So we're so excited for today's webinar, which is our third and sort of final virtual programming for Second Chance Month, that will be discussing the impact of felony disenfranchisement laws on the diversity of juries, and really the importance of a representative jury. Today, I am joined by Monica Milton, who is NACDL's Public Defense Counsel. It is she who's going to be moderating today's conversation. But before I turn it over to Monica, I just really quickly want to go through a couple of announcements and sort of housekeeping items. First, we encourage you to use the chat to introduce yourself, your organization, and where you're from. For questions to our panelists, we ask that you use the Q&A feature, which is going to be at the bottom of your Zoom screen, and we'll save some time at the end to address any audience questions. We do apologize in advance, anticipating a really robust conversation. So if we don't get to your question, we will be sharing our panelists' contact information toward the end of the session. So you can feel free to continue to follow up if there's a question that isn't addressed live on the webinar. And lastly, we want to quickly highlight sort of NACDL's code of conduct for affiliated persons. We shared this language to all of those who registered for the program, and we'll also drop a link in the chat. But to summarize, we are endeavoring to foster an environment that is free of harassment, discrimination, intimidation, and insults. And this includes any remarks in the comments or even through questions. So just ask you to be really respectful for our speakers, for your fellow attendees who are participating as well. If we do determine that someone has violated the code while participating, we will have to remove you from the session. And lastly, we want to highlight also this importance as relates to language, especially as we're talking about incarcerated and formerly incarcerated individuals. And we just ask that you refrain from using any dehumanizing language and just use language that restores dignity and humanity to those who have been impacted by our criminal legal system. With that, again, I want to thank you for joining us for today's conversation, and I'm going to turn it over to Monica Milton to get the panel kicked off.
Thanks, Monica. As she mentioned, I'm Monica Milton. I'm the Public Defense Counsel here at NACDL, and I'm just going to pass it along to my co-panelists. I'll start with Nyla to introduce herself.
Hi, I'm Nylajuan. I'm the Director of Advocacy at the Prison Policy Initiative, which is a nonprofit, nonpartisan organization that produces research to expose the broader harm of mass criminalization and supports state and local groups in policy reform efforts.
Thanks, Nyla. Nina?
Hi, my name is Nina Chernoff. I'm a professor at CUNY School of Law, and my work focuses on the right to a jury selected from a fair cross-section. And I just want to apologize now for the quality of my sound. We tried to fix it, could not. So please feel free to reach out to me. I think you'll get our emails at the end of the session if there's anything that I say that you can't hear or you'd like some clarification on. Thank you.
And Sadika?
Hello, Sadika Williams. I am the General Counsel and Senior VP of the Supportive Reentry Division at the Safer Foundation. We are headquartered in Chicago, Illinois. It is our 50th anniversary, and our mission is to help people with arrest and conviction records in regards to employment by looking holistically at that individual, assessing where they are and giving them the supportive services they need, as well as any training or employment services. We are also an advocacy agency where we firmly believe that policy and practice should walk hand in hand, so that any policy solutions we are recommending are informed by the people we're serving, as well as the practitioners. I'm very happy to join everyone today. Thank you.
Thank you. And I'm so excited to get this panel started. Why don't we start with you, Sadika, and talk more broadly about how convictions directly or indirectly impact the community you serve?
Sure, thank you. We talk about second chances a lot at SAFER, but as we've kind of been looking and reflecting at our 50th, and also the work that we do, we realize that people with convictions usually don't even have a first chance before their negative interaction with the criminal legal system, let alone a second chance. Contact with the criminal legal system, legally and socially, can be disabling in effect, resulting in substantial social and economic costs, not to mention having this lifetime of having to deal with the stigma. People with arrest and conviction records are deprived of certain rights and stripped of opportunities, from housing, education, employment, social services. When you look at colleges and universities, there are, these applications requiring disclosure of criminal history, automatically denying admission. Housing discrimination, not only are they screening for whether or not a person has a conviction, we all know that the credit checks are being used as a way to screen as well. Occupational and professional licenses. Although the industries and the state agencies would never admit it, for a long time, people have been locked out of meaningful careers and opportunities that could provide, actual living wage for them to survive. And there are so many occupational professional licenses across the state of Illinois, but also the nation. Parental rights, visitation rights. I don't know if everyone knows, but if you have a loved one and they're currently in custody and you have a felony, then it's questionable whether you can even visit them as even a child, which is just so harmful. Public benefits, voting rights, employment, debt, and it just goes on and on. And the economic fallout is widespread across all systems. And so it worsens poverty, food security, causes housing insecurity, employment, unemployment, violence, physical health needs, mental health needs, drug overdoses, education and training needs. And that's what we've been screaming, like, if you're looking for what we need to focus on, we have this issue, and it falls out across all these systems. And so the result is that you see less than 50% of incarcerated individuals having a high school education. You have 30% that are unemployed a year, post-release. The unemployment rate for formerly incarcerated individuals nationwide could be as high as 47%. Like now, as we're kind of nearing the pandemic, 10 times more likely to experience homelessness, nearly 70% with drug and or alcohol use disorders. And individuals transitioning from jail are 8 times more likely to die from overdose than the general population. And then, you have a significant amount of people who have serious mental illness and substance use disorders. And of course, people with records are just greatly, overrepresented in these social economic problems that we have.
Thanks so much for sort of giving us that overview of how broad of a reach our criminal legal system has on the lives of the formerly incarcerated, even after they've served their time. And so one of the areas that we wanted to focus on today is one of the maybe less important places that people focus on in this policy area is that people that have convictions are often excluded from jury service. And so that piece of it sort of plays into the other side of the coin of the overrepresentation of people, especially people of color on juries, overrepresented as defendants and then underrepresented on juries. And then you have this other piece that overlays that, which is overcriminalization of these communities and eliminating them either permanently or for a temporary period of time from serving on juries. And so I want to turn to Nyla and ask her to sort of give us the nuts and bolts of the really stunning report from Prison Policy on how that has actually impacted the problems around juries and jury diversities.
Sure. So, you know, when you look at the laws around jury service, and exclusion from jury service, they exist in every state. However, those laws tend to get a lot less attention than others dealing with collateral consequences of conviction, such as felony disenfranchisement laws. So we organized a report where we really want to lay out the way that the variance that exists among those laws, what the laws are in each state, and kind of the harms that jury exclusion laws produce. And one of the things that I think is really notable is actually the significant variance that exists among jury exclusion laws. And when I say that, I mean, for example, some states restore the right to serve on a jury upon release from incarceration. Some permanently exclude people for certain or any past felony convictions. In some instances, certain misdemeanor convictions can permanently exclude people from serving on a jury. Some states exclude people with conviction histories for a set period of time after release from incarceration. Some exclude people until a sentence is completed, which can include the completion of probation and parole, can also include the payment of legal financial obligations like restitution. In others, some people are excluded with a pending felony or misdemeanor charge. And still, some states have exclusion laws that differ based on if a person is being convicted of a felony in the first instance, or if they have past felony convictions, if their conviction resulted in a term of imprisonment or not, or if the person is sentenced to a year or more in prison or convicted of a crime punishable by a term of a year or more. And kind of topping that off, the period of exclusion can also differ based on the jury type you're dealing with. And that means, like, are you thinking about a petite or a grand jury, a civil or a criminal one? The laws are so significantly different across the states that it makes the issue really confusing for people in a way that they're not often aware of what the precise laws are in their states. And kind of further complicating matters there is the fact that jury exclusion laws frequently do not parallel felony disenfranchisement laws in states. So there are a number of states where you might not ever lose your right to vote, or you have it restored upon release from incarceration, but you are permanently excluded from serving on a jury. So, you know, when you kind of look at jury exclusion laws across the US, they bar more than 20 million people from jury service. And what that really does is it reduces the diversity of juries by disproportionately excluding those communities that we already know are over-policed, over-incarcerated, and receive harsher punishments, such as the Black and Latino community. And it really does undermine the promise of a jury of one's peers. And actually has also been shown to cause juries to deliberate less effectively as well. So really what we were trying to do when we published our report was pull together the laws and the literature that exist on this issue and kind of put it in one place for folks to really just have access to that information.
Thanks, Nyla. So I want to kind of open it up to all of you to sort of think through this. We tend to, I would argue that we overemphasize well, maybe not overemphasize, but we do emphasize the right to vote. And we really have a heavy focus on issues around voter suppression. And there's been this larger movement around making sure that formerly incarcerated people are able to vote in those states that do allow them to restore the right to vote. But the jury service piece is something that it goes neglected. I think is understudied as well. And it's sort of, to me, like the death of 1,000 needles. It's something that people are not paying attention to. People try to get out of jury service all the time. And certainly all of the barriers that Sadika outlined for us about how many other things that are going on in people's lives, is jury service number one on their list to sort of get, make sure that I can get on a jury, maybe not. But, I just want to think about why is jury service one of those places where this permanent exclusion is something that is so often neglected, when, we really view voting and jury service as some of those civic duties that we all find very important, and as a way to sort of integrate into our society and be citizens. Why is jury service not up there on the list?
If no one else is jumping in right away, I guess I can. And I don't want to kind of take over the conversation here, but I think that that's a really good question, Monica. And for my part, this is kind of speculation, but what I believe could partly be at cause here is the fact that compared to some of the other collateral consequences people with conviction histories face, this one comes up kind of with less frequency. And what I mean by that is restrictions on the right to vote garner more attention because, in part, elections happen with more frequency than the number of times a person will get called for or certainly serve on a jury. In addition, when you're thinking about laws and rules and practices that restrict access to, say, housing or employment, that's really something that impacts a person's very ability to live or provide for their family. Juries, on the other hand, are something I think the general public doesn't necessarily think about on as regular of a basis. There's no guaranteed kind of set dates or times like there are with elections. When you receive a jury summons, it's unpredictable, right? You don't know when you'll receive it. You don't know if you'll get called for voir dire. You don't know if you'll get selected to serve on a jury. And in fact, a 2007 study estimated that about 15% of US adults receive a jury summons each year, and only 5% of those individuals then actually serve on a jury. So it may just be that for some folks, this doesn't seem like as urgent of an issue when faced with the other problems that individuals are faced with upon release from incarceration. And I could go on, but I'm going to pause there and just also note that I do think that one additional important thing to recognize is the fact it is starting to garner more attention. There has been movement in states recently. The formerly incarcerated and convicted people and families movement has this on one of their national policy priorities, and groups like Voice of the Experienced in Louisiana have really led the push for reforms in their state. So you are seeing this kind of come up more and more.
I would add to that too, that it hasn't captured the public imagination the same way as voting. I think, frequency is one piece, and another piece is the gap between accessing the power that the right gives you, because voting gives you the power to decide who's going to make the laws, and jury service gives you the power to implement them. But there's a big gap. As soon as you get to the voting booth, and Lord knows they're trying to make it harder to get to the voting booth, but once you get there, then you're immediately accessing a lever for Joe Biden or Donald Trump. With jury service, you get your summons, and then there's a lot of admittedly boring administrative steps between you and the action and the exercise of that civic power. And I think that gap between getting called and actually deciding how the law should be implemented sort of interferes with the ability to catch people's attention, both in the context of people with felony convictions who've got a lot of other issues on their plate, but also with the public generally. It doesn't get the same attention as voting.
Also, and I just wanted to add too, I think most people, including those who have been directly impacted by, especially negatively by the criminal legal system, from their direct experience in their lives, they're thinking, this is going, there's no room for me. I'll get excluded. When people of color can't even get representation for jury service, then how is it going to ever be possible if you have a felony in most people's minds? I mean, so in some of the occupational licensing reform work that I did here in Illinois, when we passed the reforms, people were like, what? Really? I never even thought that was a possibility for me. And so that was still is one of the biggest barriers, which is, if people don't even think that it's a possibility, then they won't, inquire about it, and they won't ask about it, and they won't push it. But I would say that I would acknowledge that there are leaders increasingly, who have had felonies at some point, and they are advocating around this issue. So even if, most people who have had some touch are not paying attention to it, there are advocates who are starting to, because they want to address the harm that was done to them and their families, and ensure that anyone else who have had or is having that experience, hopefully one day can have a better, experience in a true jury of their peers. Because at this point, it's not happening, and that's supposed to be a constitutional right.
So I want to shift a little bit and to talk about what are the reasons that we are able to justify excluding people with convictions from jury service. What are the arguments that people posit for this kind of policy? And I guess I'll turn that to Nina.
Yeah, I think there are probably three main justifications. And I want to say that I'm getting these insights. I'm sharing insights from Professor James Banal's book, 20 Million Angry Men, The Case for Including Convicted Felons in Our Jury System, which is one of the best and most comprehensive recent reviews of this issue. And Professor Banal identified three main justifications. And one is the claim that people who have felony convictions don't have the character that's required to be jurors. They don't have the integrity or the conscientiousness or the honesty that's required. The second justification is the claim that people who have a felony conviction are going to be biased against the government, and that somehow that bias is more deeply entrenched or more problematic than the other biases that everyone walks in with. And the third justification is about a concern about how the public will view this if people with felony convictions are allowed to serve as jurors. Both how will people feel about serving on a jury with people with felony convictions, and how will the public feel about verdicts that are rendered by people with felony convictions. And I mean, I can't say the justifications without just flagging sort of some overarching problems with those justifications. I think my co-panelists are going to speak to that more directly. But first of all, these are all justifications that are based on conjecture and not empirical data. And in fact, the empirical data that's coming out now undermines some of these justifications. And second, the idea that a felony conviction tells us something about your character ignores racist policing and prosecutorial practices. And in fact, a felony conviction could be telling us a lot more about an unjust criminal justice system than about anybody's character. So that argument falls apart. And then finally, it's categorical exclusion from juries, or a broad exclusion for people with felony convictions, is too blunt of an instrument to address the issues of bias. Like, if we're concerned about bias and people who can't put their biases down to decide a case fairly, we both have and can develop tools for that. This kind of blanket exclusion isn't the best way to address that. So happy to talk about that more. But
so just to the point about creating an anti-government bias, doesn't felony exclusion or jury exclusion, because you have the felony, create a pool that would have a pro-government? I mean, if that's one side of the coin, is that this person can't sit because they have an anti-government bias, is that other side that it's not neutral, it'd be pro-government, a pro-government bias? Or can that argument be made around this?
yeah, I mean, I think the right to fair cross-section isn't a right to a jury that doesn't have biases or opinions. The idea is, of course, that we get a whole bunch of biases, a representative sample of the biases in the community into a room and through the process of deliberation. Because after all, it's not that people come in and just vote with whatever biases they're starting with. they have a conversation, a dialogue, and that produces something ideally richer and more accurate. And so if have this blanket exclusion, we're excluding people who have this unique set of experiences that could, but doesn't necessarily give them some critical perspective on the system. And then functionally, because of the way that we enforce the laws, we're excluding Black men in particular and people of color more generally. So we're missing out on all those perspectives. So it's not that, the violation here, the constitutional problem isn't that the defendant isn't getting enough people with anti-government bias. It's that, or perhaps another way to say it, is the government is kind of tipping the scales by giving the thumbs up or welcoming in certain sets of biases, pro-prosecution, pro-government, and keeping out the counterparts that would contribute to the jury's ability to actually do what it's supposed to do, which is reflect the judgment of the full community, not just part of the community.
Thanks. So I do have a question from the audience that I want to ask before we get too far along. And this is for anyone that wants to answer on the panel. He asked, how would you respond to a question from someone, not me, who opposes lifting the felony conviction bar? Isn't jury service a more substantial and consequential act than voting? And if so, shouldn't there be more criteria to serve on a jury? Again, this is not me, but I'm interested, just to add that caveat that he had. So thoughts?
I guess I do think that it's a substantial right. I think voting, though, I would never undermine the power behind voting as well. So I don't want to say that, but I guess I don't. Okay, so a pet peeve of mine is throwing a question to a question, but in this case, it might be appropriate, which is, well, what should that be? What should the eligibility standards be, right, in order to be deemed a reasonable and qualified voter? Because my personal experience is that I am not. When I got summoned for jury duty about 2 months ago, I am not. I was deemed as, not preferred. And the whole time that I was sitting there, I knew they weren't going to select me. I'm an attorney. And like I listed out, yeah, I'm an advocate for for people of color and for, removing barriers for the criminal legal system. So I knew that they were going to probably not select me, but there were only like 5 other minorities in a room full of like 80 people, and none of them got selected with me. And so what makes us preferred? I mean, the whole time that I was sitting there, I've been having and I feel like COVID has just kind of worsened this, but I just was having feelings like, okay, well, what makes a person a good juror? Like what makes them preferred to like the rest of people here? There's some things off the top of my head that would be reasonable to look at when selecting jurors, including if there's like a conflict of interest, if there's, including a substantial relationship. And I understand the need for bias, but I think, as it was pointed out by Nina, it has to go both ways in terms of the bias, because and my mind goes in terms of, okay, well, what does that analysis look like? And that's where I think we really start getting into the complexity of this, because even if we remove these barriers, there's still the discretion of the parties that are involved, right? And so is there a standard really that would be applied consistently? I don't know. So sorry, not really. I just some mindful thoughts to address what you're saying and how complex that consideration is. Just coming from a viewpoint of a woman of color who recently served as a juror, and I definitely felt that I was not enough as an attorney. So what is it going to take? Do I got to jump through some hula hoops like to be a reasonable person? Did the other jurors have to as well?
Well, and the one thing that I would add too is like kind of reflecting back on what Nina was saying, which is like, having a systematic exclusion is quite a broad instrument to use. And when you think about the process that already exists with juries, right? The fact that people do go through voir dire, the fact that jurors are kind of pulled out of the overall pool based on a series of questions, which, have problems in those processes within themselves. I mean, you're already having additional filters added, right? So do you really need such a systematic exclusion, even if someone is making this argument, right? And I think that it's also important to reflect on the fact that actually more diverse juries are more likely to be viewed as legitimate. They're also ones that are more likely to respect different racial perspectives or confront prejudices and stereotypes, and therefore are actually grappling with the issues that they're dealing with more. And so I think it's important to kind of, push back in those ways if you're confronted with these sorts of questions and saying well, what are we actually losing from the process when we exclude entire segments of the population and really reduce the overall diversity of juries?
I would just add that with juries, unlike maybe judges or politicians, we're not looking for the best of us, the most well-educated, the most thoughtful, the strongest interpersonal skills. We're looking for a group that represents who's in the communities that we live in. And whenever, so that's one piece. It's less about who's qualified than who's here, because that's the key point. And then it also, and we sort of emphasized this already, but using a felony conviction as a predictor of do you have the character or the skills only makes sense if the felony conviction is actually tied to misconduct and bad character. So again, we'd have to assume that all the people who have felony convictions, notwithstanding what we know about policing, actually have engaged in conduct that reflects bad character, and that the people who don't have felony convictions, who are perhaps in communities that are not over-policed, and so they can commit the same conduct and not end up with a conviction, have that character. And I just think we know too much about how the criminal justice system works to really rely on that as a tool for assessing whether people have whatever low-level requirements we might have for character traits for being on a jury.
So can I ask Nina, I know this is your space. How does, equal protection play into this? Just thinking about Sadika's experience of feeling well, what would it take to be good enough to serve, good enough to serve on a jury? That experience for a lot of Black potential jurors would be a negative one and make people feel as though they are not, good enough to serve, being a part of the society that we're allowed to serve on juries now and not excluded like we used to be back in the day. So how does that play into this felon exclusion piece?
The equal protection right?
Yeah.
Well, that's not my space, Monica. I like to stick with the Sixth Amendment fair cross-section, but I will travel over to the 14th Amendment and just say, with regard to equal protection, the problem is that because people with felony convictions are not a suspect class, it keeps getting rational basis review, which, as we know, is sort of like no review at all. So that's one major obstacle in the equal protection sphere.
And how does this impact fair cross-section, or why isn't it viewed as a violation of the fair cross-section?
Okay, now I'm more comfortable.
Now you're back in. Yeah. We got you back to the right lane.
So the reason that claims, when criminal defendants are raising the claim that my jury is not representative in violation of my fair cross-section right, because you have this or federal government exclusion of people with felony convictions, it interrupts their claim. The courts put up obstacles to their claim in a couple different ways, because in order to make out that claim, the defendant has to identify a distinctive group in the community, show that the representation of that group in the jury is not fair and reasonable when you look at the percentage of that group in the community, and then show that the reason for that underrepresentation is something inherent in the jury selection process, in contrast to, say, random chance. And then once the defendant makes out that claim, the government has the opportunity to offer a rebuttal and say it's justified by a significant state interest. So what courts do is they say, you, criminal defendant, cannot satisfy this first prong because people with felony convictions are not a distinctive group, which is doesn't really make sense when you look at the definitions of distinctive group that are in the case law. And it's also a little ironic to say, oh no, people with felony convictions don't have anything in common, so you can't call them a distinctive group. But they have so much in common that we've decided to legislate them out of the jury process because we think we can make some judgments about them as a group. So that's the first issue, is that defendants aren't allowed to identify people with felony convictions as a distinctive group. And a related problem is that courts refuse to recognize intersectional groups as distinctive. So courts will say, Black people are a distinctive group, men are a distinctive group, but no, Black men are not a distinctive group. And that's problematic because when we want to show, look, this is the percentage of Black men in my community who are excluded because of this rule, which can be 30 or 50% of Black men in a community, you're not allowed to describe the data that way because you're not allowed to define the group that way. So that's the second problem. And then I think the third issue that I'm sort of identifying by analogy is that even if a defendant was allowed to identify Black men as a group and show that they were underrepresented as a result of this exclusion, the government then still has an opportunity to say this advances a state interest. And presumably they would argue the same interests that are used to justify the exclusion in the first place. And we have seen something similar in federal courts in Puerto Rico, where defendants are able to demonstrate that the English language requirement excludes a huge percentage, majority of people who live in Puerto Rico in the Latino community. And yet courts have said it's not a fair cross-section violation because the government has this interest in English-speaking juries. So I think that's a third obstacle to fair cross-section claims.
Thank you. And so I guess I would turn it to, or open it up to everyone to really think about how this, the jury exclusion laws impact jury diversity overall. And what does that mean? Because I think that those are really good questions. What does that mean for outcomes? And
well, I guess there are two studies that we had pulled information from that I think provide interesting facts and kind of go to some of what Nina was just discussing about, like the ability to look at like Black men as a group, which was like there was a 2011 study that found in Georgia, 34% of all Black adults and 63% of Black men were excluded from juries because of criminal convictions in that state. And in New York, it's previously been reported that about 33% of Black men are excluded based on conviction history. So like taking that into account and thinking about how, we already know how many people already are getting excluded through like the voir dire process, or like not even taken in for voir dire originally. And then when you're like further dwindling this down by like that percentage, that has a real impact on what juries look like. And, as I already mentioned, like more diverse juries like really do change what the discussions look like, really do change whether people are confronting stereotypes or prejudices that they have, impact like the views around like the legitimacy of a jury and its verdict. And so I think that, the ways that like the over policing and over criminalization of certain communities really reduces the diversity of the jury pool has a really detrimental effect on how we view our criminal legal system and its legitimacy overall.
I would just say the exclusion results in the real experts being excluded. Because people who have been through the system, who have had experience, are the real experts to lend to that conversation. And we're just excluding them. Who better to know than individuals who have went through, a jury themselves and had experience on the prosecution and the punishment side, right? And I think when we think about the importance of having that diverse representation, no one wants to be in a situation where the individuals that are weighing the facts, right, of what happened to them can't relate at all, can't put themselves in their position, or just could, because they've never had those type of experience, could possibly empathize with them, because it's like night and day. If you haven't had some of these experiences, a completely different world. So when we to me, it's about justice, real justice. How can a person have real justice if they don't have a fair group of their peers to objectively make a decision? It's not fair at all, and it's not justice.
So, Sadika, you have a ton of experience with, the ongoing discussions you have with the community you serve. How they describe their experience with their juries. Have any of them talked about concerns about the makeup of the juries they were in front of?
Absolutely, but it's a trauma, response. Most of the times that it's mentioned, it's always thinking about a harm, right, that has been done to them and their families because of the result of that. That, all white juries, no representation at all. They felt like they got thrown to the wolves, and they did, and I've spoken with some who are like, I absolutely, did not do what I was accused of, but because, the jury I had could not relate to me. And also they didn't have representation like they should have. They were subject to be harmed by our criminal legal system. And as a result, every facet of their life negatively impacted, and it'll be perpetual for generations, because repairing that kind of harm takes generations. It takes decades to do with your family. Once you have that interaction, it impacts the kids, and it's just so devastating. And so when they think about that system, that's what I was saying, like, why isn't this a higher issue for folks? When they think about it, it's not a positive thought. They're not like, oh, it's wrapped in the trauma of their overall experience of what they had to go through, and it's just not positively thought about. But as I mentioned, there are advocates who want to help others, who are going through that experience, and they want to reform it, and so they're passionate about leaning forward and trying to examine what they can do, even if it's just making sure that people know their rights, in the state, or even if it's just having education sessions, bringing in groups to talk about different types of, opportunities. And so, it's just, I would say more on the advocacy side, or we're seeing it being discussed, but it's definitely, but just because we're not talking about it doesn't mean that it's not a big problem, because it is. And I don't know what the solution is.
I just want to follow up on that, is given that they did have this negative experience in the criminal legal system, do you imagine that there'd be reservations around, like, let's say they took the ban away from, everyone's given access to serving on juries, no longer this ban. Do you think that people would feel inclined to participate given their experience? Or do you think it would be something where people are like, I don't want anything to do with this court or anybody in it?
It's kind of like, even if they took a ban, let's be honest about theory versus practice, right? In terms of jury selection, I think we still would have challenges, because lawyers can get around issues with their challenges and still get the same result. And, enough people have that same experience. People, when they've been let down over and over and over and over again, people don't want to be, deal with that kind of stuff. So they're still going to be, even if it's removed, they're not going to be trusting of that process because the process hasn't been working in their favor. And it's going to take substantial education and demonstration that things have changed. Like, it'll have to be a demonstration. They will have to see it in order to I believe, change that perception. But even then, like, the whole process itself is questionable in terms of the compensation, and like the realities of people's lives, and like being able to just drop everything and go serve is like, if you're working certain types of jobs, you're just not going to have the flexibility to do that. And you're going to be looking for any type of way to get out of it so you don't lose your job. So that's another reality too, right? Is like the demands of it when you have a job that doesn't allow for a great flexibility and it's pretty rigid on your breaks and your time off.
That's a great point. I want to turn to Nyla to let her kind of describe, let's say people are in states where maybe they're not permanently disenfranchised. Can you describe the challenges for people with criminal convictions in trying to become eligible for jury service?
Sure. I mean, like I noted before, like there's some things that some states where it's like required that someone complete like probation, parole, or repay certain like legal financial obligations, which that can serve as a barrier or something that extends having your voting right or your right to serve on a jury restored. One thing to like separately note and think about is like, while in most states you use multiple sources for lists for the jury pool, right, where they're using voter registration lists, state license and ID lists, possibly like income tax or unemployment compensation information or other unique statewide lists, there are some locations that purely rely on voter rolls. So then there's the whole separate complication mentioned earlier where sometimes folks don't know what they're, whether or not they qualify to vote. They assume that they do not because they're most familiar with the most restrictive laws, which have prevented people from ever registering and voting again. And they may very well live in a state where their right to vote was restored upon release from incarceration. And if you happen to live within one of the jurisdictions where the jury pool is being fully pulled from the voter registration lists, you have to also be aware of your voting rights and have registered. And then, obviously in states where people are typically permanently excluded, there's things like the pardon process, or in Utah, having to go through an expungement process. But one of the states that I find really interesting is Florida, where, after Amendment 4 was passed there a few years ago, restoring the right to vote for some people that had like former felony convictions upon completion of sentence, the state adjusted its clemency or its jury service rules and basically said at that same point in time, someone can qualify to serve on a jury. However, their right to vote is automatically restored. Their right to serve on a jury is not. They have to still submit a paper and get that processed. And like the paper doesn't require a hearing, and it does result in an automatic restoration of the right to serve on a jury. But I don't know how well publicized that was. I don't know how many people go into that thinking, oh, my right to vote was restored, these other rights have been restored too. Or conversely, just have no idea that their right to serve on a jury has been restored and actually are going and filling out that paper and submitting it, right? I'd be really curious to know what in practice that has looked like in the state of Florida since they changed those rules.
So in the states that don't do automatic restoration, I know you just touched on some of the ways that, people can try to get back on a list to get, like they re-register to vote automatically or something like that. But this is being so complicated across the country, what kind of national policies could we think of or implement that relate to this issue? Because, I know that you and I had worked on some of this stuff, but looking at individual states, so many of them take such a different stance on even whether you fully served your conviction, either with fines and fees. So is there a way to do some sort of national advocacy and policy around this stuff?
Well, in terms of national advocacy, I think that could be difficult because of how much these rules vary. But one thing, like a couple of things that I can think of that would be like helpful in the process is like actually like improving education and outreach on these issues. And that can happen at like several different points. Like when people are being released from incarceration, the information they get should include information about when they have their different like rights restored, whether that's the right to vote or the right to serve on a jury or the right to hold political office or something else. Also, there are a lot of groups that are working on issues involving collateral consequences of conviction, and groups working to educate people who are formerly incarcerated about their voting rights. This is something that I think could actually pretty easily be slotted into some of these education and outreach efforts that are actually already taking place. And I think that's happening in some locations already, but maybe not as many as like is possible. And then also, I'm just thinking about like if someone receives a jury summons and doesn't actually realize that they can serve on a jury and is confused about like, can I do this? What does this mean? Just making sure that the materials that get sent with the jury summons really explicitly explain what the jurisdiction's laws around jury exclusion are so that people understand that when they get something in the mail too. I think that those would all be like helpful touch points. I don't know that any of those solve the problem entirely, but I think that there are different points of intervention that could be helpful.
Any other thoughts from folks on maybe a national policy changes or even state changes?
I think what would be helpful is like a model rule or policy that advocates could use locally if they were looking to reform any kind of rules or any legislation, bring forth legislation, because it's not enough to just get rid of the exclusion. I feel like you need to drill down into what constitutes fair character and integrity, because when I work with my team in Illinois as it relates to occupational licensing, how they were able to exclude people who had felony convictions from licensing and other certificates was based on good moral character. That was their catch. That was like how they did it. And they were excluding people solely on the basis of the conviction itself, without looking at any other kind of factors, including the nature of the conviction, how long ago it happened, what were there any evidence of rehabilitation, like what was the total picture, right? And so we made sure that in the language we clarified you could not use that standard anymore, based solely on the existence of a conviction, and that they had to consider those other factors as well in their determination before excluding. So in this political climate, probably not, it wouldn't go very far, considering the pushback we're getting at every level of government for significant reform. But if we wanted to truly make meaningful change, that's the way you have to start drilling down to see some change there. But whenever you go for any judicial reforms, it gets crazy quickly. I've learned lots of pushback by county. So, and it's so highly political, it's so political and it gets nasty. But we could, but it's not going to be an overnight fix. it has to be hyper localized. Maybe, like I said, a model rule policy that could be shared with a toolkit, with the caveat that your jurisdiction could have its own nuances, rules that you'll have to kind of adjust, for. But here are some things to think about. That would be my recommendation, in addition to the education outreach to people that are impacted.
Great. So I think we have about 5 more minutes. So I wanted to open it up for your final thoughts on this topic of increasing jury diversity, particularly in the space where, ignored populations, formerly incarcerated people. What are y'all's final thoughts?
I mean, one thing that I keep thinking about in this context is that we are endangering or undermining a core constitutional right to have a jury of your peers in order to elevate a legislative decision, a statute that's not based on real data. And that just doesn't seem like a good process for arriving at good outcomes. And we're certainly aware of the harm. So I think my thought is, particularly as we as advocates and being led by the Black Lives Matter movement are thinking a lot about unjust law enforcement, that diversifying the jury is one of the tools, a tool designed by the framers to have the voice of the community come in and interrupt the force and the reach of government action that might be motivated by malice or apathy. And so I hope that all of the energy that we're bringing towards fighting unjust policing and prosecutorial decisions can be connected up to using the jury as a tool to also fight unjust prosecutions.
And I guess I would say I have found it really encouraging recently to see how many of these reforms have started moving in different states, how many reforms were passed even in the past 2 years, and how many pieces of legislation are currently in front of legislators. It does kind of make me feel like this is an issue that's gaining more traction, and hopefully we will see more movement on. I know I've been comparing kind of the right to vote to the right to serve on a jury quite a bit. But when I've spoken to people, they've been constantly kind of surprised that when those rights are restored varies so significantly, and that a state like Vermont that never strips people of their right to vote will permanently prevent you from sitting on a jury. And so, I think that really also forces us to open up and have a conversation and examine why we treat these different sort of collateral consequences of conviction so differently, and what plausible explanation could exist for doing so. And I think it kind of opens up a possible window to continue to push for these reforms as well.
And I know I agree with everything that's said. I know we're closing. I also just wanted to note, I think we should pay attention and promote any types of innovation that are emerging as a response to what's happening, including participatory defense, that is gaining traction, where, the families are getting involved. There's CBOs that are working with the defense, working as navigators is what we're calling them, to pull in a family so that it's, they're having more support, their families present in the courtroom, they have, more character witnesses. So there are alternatives that exist as well, that I'm seeing grow. And so perhaps if, recognizing that we have this significant challenge in the system that's very, bureaucratic and political, maybe there are other innovations that we can promote as well as at the same time that we're pushing any reforms.
Great. So we're at a buzzer beater right on time. I'm going to kick it back to Monica. Thank you to our panelists. This has been a great discussion, and I'll hand it off to Monica.
Thank you so much, Monica, and echoing your thank you and support to the other panelists for just sharing and taking the time to sort of share their expertise and thoughts on this topic. We're going to put up sort of a survey slide. So definitely, fill out the survey. You'll get actually a copy in your inbox as well. And just let us know what you thought of today's conversation, the topic, and also make suggestions and other sort of issues you would like to see us undertake at future sort of virtual content. This is our last sort of second chance month programming, but you can definitely visit our website to hear recording some of the previous webinars that we talked about. Today's session was also recorded, so once it becomes available, we will notify everyone who is registered, and you will get that link, and it'll be available free and publicly available on our website. Again, thank you to the panelists, and just thank you everyone for joining us for today's conversation, and we'll be in touch.